I have a couple of great guests with me here today. Liisa Thomas is here. She is the author of A Perilous Patchwork, which is the report which you can pick up in the next room if you haven't already. Really worth taking a look at. She is a partner at Winston and Strawn and chair of their global privacy and data security practice. Liisa, thanks a lot for being here. Doug Gansler is also here. Doug is a partner at BuckleySandler. He's a former Attorney General for the state of Maryland and was president of the National Association of Attorneys General, and in that capacity, you took a special look at cyber, didn't you, Doug?
I did. That was our year-long program. We had privacy in the digital age, and we started, that was 2012 and 2013. At the time, they said, well, by the time you get to be president, that'll all be solved. Those problems will be behind us, and obviously they're proliferating now.
Still very much with us.
Very much
still
so.
very much with us. Thanks both for being here. Liisa, in your report, you take a look at the landscape here where it comes to regulatory enforcement and data breaches. It's a very confusing landscape, isn't it?
It is. It is. There are many different regulators, more and more regulators that are getting into the fray every day, it seems like. And it's a lot for people to keep track of. It's a lot for companies to keep track of. So we have, at a federal level, we have regulators like the SEC or banking regulators, those that are in a regulated industry, companies in a regulated industry are familiar with, and they're looking at companies that have been breached. At a state level, we have attorneys general who are thinking about what are companies doing to protect their information when they get breached. We also have that same level of scrutiny from the Federal Trade Commission at a federal level.
So there's no clear roadmap when anybody's trying to navigate any of this.
It's clear that it's murky.
Well, it's worse than that. There's 47 states with different notification rules. So if you're, the FTC has been traditionally the most vigilant in this area. So you have the FTC, and then you have 47 different state notification rules, and so it's very murky.
And if you operate in several states, it becomes even more difficult, I presume.
Even if you don't. If you're,
and I think one of the things that you mentioned that makes it even more confusing is that we have these requirements that we have to raise our hand and say, we've had an incident, Jayson broke in. I'm very nervous now. I was talking to him before, and he was wearing his glasses, so I'm a little afraid to go back and talk to him. But we have an incident, someone breaks in, someone steals our information, we've had a data breach, those laws are triggered. Once we raise our hand and say that happened, as we are required to do by these 47 different laws, then the next question becomes, what is the regulator going to come to us, or what's going to happen to us? And it's not going to be you didn't do the notice correctly, maybe they'll criticize us for delaying the notice, but really the question is going to be, were we the cause of the breach? Were we the ones that caused it to happen because we didn't have enough security measures? So the minute that the notice goes out, the focus shifts to, let's look at the underlying security that the company had in place.
Let's talk a little bit about the FTC and its role here. What's its regulatory authority in this area?
Oh, okay. So the Federal Trade Commission operates under Section 5 of the FTC Act, which I usually refer to as the mom law. And it's would you make your mother proud if you did what you did? So don't be unfair and don't be deceptive. And in a privacy world, deception might be, we use the best security measures ever. We've got fabulous security measures, and then you turn out to be the company that Jayson won't even do the penetration test because you don't have any security measures. Right. So that's deception. And unfairness is you've got really sensitive information, you didn't protect it. That is fundamentally unfair.
Yeah, I mean, that's exactly right. It's not necessarily what you would think, because they do put it into the UDAP statute. But basically, the idea is if you give your information to a company, the deal is that you're assuming they're going to protect your data. And if they don't, then the company's in trouble. And the company doesn't get out of it by having third-party vendors or what have you. It's going to be the company that's ultimately responsible from the FTC and then the state AGs as well.
So let's talk about the state AGs. How interested are they in this?
Well, the state AGs are getting much, much more interested all the time, and because they are guardians of the consumer, and the consumer now has been breached. And so what's going on, when I started the first internet safety unit in the country, Maryland, and California has one, Illinois now has one, Connecticut, and other states. And what they do is, on a monthly basis, they go over what the breaches were, and they prioritize which companies are going to go after and for what reasons. Is the FTC already going after them? Are other states going after them? They may go after them individually as a particular state, or they may form a multi-state and go after them in that regard.
But they're being very aggressive.
Some
of the AGs.
They're being, well, almost all of them are being very aggressive, and they frankly should be for some of the companies that are putting up the sandcastles. It's the companies that are doing the work to try and protect themselves that they ultimately don't go after, because they have to prioritize. I mean, a little state like Maryland last year had 314 notifications just to the AG's office. You don't hear about a lot of them because lawyers come in and they solve the problem, that kind of thing. But there are a lot of them, and they can't go after all of them, so they have to decide which to go after and which not.
And how do they make that decision?
Well, they go after if a company's put in their firewalls, done the safety measures, has an incident response plan, has training, and I think the sketchy dude was totally right. The way to do it is to train your employees, because they're going in now through phishing and spear phishing and targeting particular people. If the company's done that and then a nation state comes after them, they're going to generally let them be what they are, which is a victim. If they've done nothing but told the public they're going to do a lot of things, then those are the companies that are much more susceptible.
So you said 314 reported in Maryland. Any idea how many they've seen in a state like California, for instance?
Thousands. And then they also have calls, and they decide which states, a target or something. And any breach you've heard of, the AGs have been involved in. And with all due respect to the federal government, the states are a little bit more aggressive. They have less bureaucracy. They'll go after more of these cases in the future.
Liisa, what about the federal authorities? How do they prioritize? Who do they decide who to take enforcement action against?
I think it's what is going to make a reasonable case, and it's exactly as Doug said, does the company have adequate security measures in place? I think, though, there's a feeling, especially when I'm talking to my clients, that when we talk about being prepared and we think about down the road what's going to happen to us, many times we talk to the business teams that will start to make the argument to us as the outside counsel and say, well, here's all of the wonderful things. And I have to explain, well, if we are now talking about the arguments, then we're going to be making the arguments to the government authorities, whether they're the federal regulators, whether it's the state attorneys general. And if we're in that position, we're spending money, we're spending time, we're putting a case together. And if ultimately and this has happened to me many times, if ultimately the government authority decides we're not going to pursue this, that doesn't mean that it didn't take up a significant chunk of folks' time and a significant chunk of money to get the regulator to understand that you really don't need to investigate us because we were the victim
and
here.
The flip side of that is we've walked out, I'm sure you've had the same experience, where companies will say, the general counsel in particular, the CISO or the privacy officer will say, oh, we've got this. We really do a really good job. And you're trying to get their business, so you don't want to be mean to them. But in the hall outside, you're like, oh my God, they have no idea how exposed they are. And yet other companies think they're not doing a good job and actually are doing a good job. And so there's a lot of things, and I always look at it, I dabbled in politics for a while, and so you have, the politicians will never say, elect me, I'm going to fix your sewer. And there's no budget for the sewer. Right. And now companies are realizing that it's not very sexy, but they have to allocate some money toward the protections and getting lawyers to fix themselves, or they're going to end up having this huge exposure.
But don't you find that there are still some corporations who don't want to spend that money?
Most don't want to spend the money.
It's actually interesting. I think the ones that want to spend the money, we think are the ones that have suffered an incident, and certainly they are. But it's the ones that are often, I'm approached by the ones that are the competitors of the ones who have been impacted. And so most of the time they spend, thinking, well, this would never happen to us, but oh my goodness, if it does, we better get prepared. And my favorite part is when they decide that they're going to do an analysis of everything that their competitor did and redo it and show that how during the incident, during the disclosure, they could have done a better job.
Yeah, and I think they're going to start spending the money a little bit more now, because what's happening is it's really from the top down now. The board level, or so the people in the C-suites are starting to get nervous. They read the newspaper, they see what's going on. They're like, are we exposed? What's the exposure for our company in terms of defamation, reputational harm, as well as financial harm? And so they're going to their general counsel and say, look, fix this.
Do you find that some industries are more apt to have taken the protective measures they should have than others?
But the financial services industries are
They're way in
certainly
front.
way in front, yeah.
Yeah, I'd agree with that.
So given this very complicated landscape that you sketched out for us, it's possible then that any company who had a breach would be faced with action from more than one player, right? It could be federal, it could be the AG, it could be a couple of federal agencies potentially?
It would depend on the incident. I think what I usually try and prepare a client for is a potential that we may be facing scrutiny at a federal level, we may be facing scrutiny at a state level, we may be facing shareholder inquiries, scrutiny, lawsuit, and we may be facing class action lawsuits. And all of those could happen either at the same time, they could happen with some coordination, or they could happen one after another.
Yeah, and it's not a if, it's a when. I mean, they've all been hacked, and the question is when's that going to come to the surface, and what have you done about it, and how have you done the notification? I mean, the response to the breach and when you find out about it really sort of informs what's going to happen to you next, and who you're notifying, what kind of steps you took before, and who you're notifying after. You know, are you putting credit monitoring in right away when PII, personal information, is taken? Are you going to, companies like ID Experts and healthcare companies that when your healthcare information's been taken, and that's sort of the next space. Now you're looking at a lot of these healthcare companies that are being breached and what's happening to people's personal health information, which is actually in a lot of ways more dangerous than financial information.
So let's talk a little bit about the class action phenomenon. Are you seeing a proliferation of those suits?
Well, yeah, because you saw the television screens. The problems with you do see most of those. The problem they're having, the private bar's having, is showing damages, actual harm, which is very difficult. First,
You can't go in and just say, somebody has my personal information, they could hurt me.
Right, yeah, have to show the damages. And that's more difficult in the private context, though it doesn't stop plaintiffs' lawyers from holding companies hostage for settlement. But in the government context, the UDAP statute, you don't have to show harm. You just have to show it was deceptive, and once the breach happens, the government can come in.
So are these class action suits, are they being successful, Liisa, or for the most part are they not?
It's a mix. There are some that have been successful. There are some that argue that, and courts, it's rare, but courts have agreed that the time that I spend trying to run around and fix or protect my identity is a harm to me. But a lot of courts have dismissed those types of cases, saying that there isn't harm to the individual.
Ashley Madison, that'll be successful.
We all remember the Ashley Madison.
That's reputational harm.
Yeah.
And what suits have been filed, for instance, as a result of that one? Speaking of Ashley Madison, do either of you know?
No.
I'm just curious.
It seems one of the things that's
They're all
interesting.
trying to hide under a rock.
Yeah, exactly.
Well, and one of the things I think that's interesting about the area that we're in is that I feel like every day there's a new lawsuit that passes our desk, and they keep coming and they keep coming. They just don't seem to stop. But I was thinking back to this concept of being prepared, and we're talking about the lawsuits and the inevitable lawsuits. I'm not sure. I always hesitate to say to a client a lawsuit is guaranteed or inevitable, because there are so many breaches that occur where we provide notice, we give notice, and nothing happens.
Most of them.
Most
cases don't result in a lawsuit because they're now taking action.
Or people don't notice them, they really don't garner a lot of interest from regulators, from the press. And one of the things that I try and do when I'm working with clients, and it all goes back to training, it all goes back to being prepared, is to try and get them to think about which for lawyers is always very interesting, how are we going to handle the PR? And how are we going to handle these statements at the very beginning? The question that I will often ask is, what if it leaked on Facebook? Are we going to answer the Facebook post? What are we going to say?
Is there a hard and fast rule on that? Or does it depend on circumstances?
I'm trying to mitigate against, we don't want this to blow up. So on the one hand,
big enough, it's going to blow up anyway.
if it's big enough, it's going to blow up and we're going to want to respond. But if it's so small that nothing's really happening, if we respond, are we going to make it even bigger? So I try and force my client to start thinking about that in the beginning and to think about what are they going to say? What is their story? So that they can't just say, oh, we're lawyers. We're going to focus on the investigation. We're not going to pay attention to anything else. We're going to find out the facts and we're going to answer the legal question and we're just going to keep our vision very tunneled on that.
Especially for the bigger companies, the ones that you're going to hear about, the communications at the beginning is the way to stem the reputational harm of the company.
So what's the advice? What do they tell the public?
Well, it does depend on the situation and who, what kind. The first thing you have to do is figure out what kind of information was compromised. Was there a breach? Is it going to go public? What is the type of information that's been compromised, and what is the potential use of that information? And make sure that you've done the notifications to both your consumers, but also to the regulatory authorities, and then make sure you're doing a communication about we've got this under control,
Yeah.
but don't hide from it.
And I try, if we know absolutely nothing, we know nothing, but somehow this has gotten out. We take this seriously. We're investigating this. Where we run into troubles is saying, oh, we know we had a breach, or I've seen ones, not clients that I worked with, but I've seen companies say, we had a hacker break into our system. We don't know what's going on. We don't know if anything has been compromised. It's early days and we have no idea what's going on. There are lawsuits still pending on ones like that.
So you mentioned notifying the regulatory authorities. How do you know who to notify in such a confused situation?
You come to lawyers like us.
Yeah, you do, and it's not only who, it's when. I mean, the example that Liisa just used is a good one because now you're scaring everybody, and it may turn out that there was no compromised information. It's just what they call a data incident as opposed to a data breach. But you know you have to notify your state, and you know you have to notify the FTC. But yet there's different. If it's a securities case, the SEC. So there's kind of a list, but you go to lawyers and they'll basically talk to you. You'll have the conversation should have already happened with the in-house lawyers and the outside counsel. And by the way, that conversation, the very fact of that conversation is a lot of things that companies don't do. So when the regulators come in and say, well, who have you talked to? Have you seen had an independent analysis? If you talk to independent lawyers, even though you're paying them, it's not really independent, but it's not just you internally saying, yeah, we had measures. We've talked to someone outside. We've had a gap analysis. We've looked at a risk analysis, and we thought we were protected. It turns out we weren't. We're victims here.
Does attorney privilege come into play at all in those conversations?
Absolutely.
An important factor.
Yeah, attorney-client,
So
and then some.
best to have these conversations with the lawyer as opposed
Best to have conversations with the lawyer, and some law firms will actually then hire the consultants that work for the law firm, so even the consultant work comes under the guise of attorney-client privilege.
Yeah, and that's really a big issue that we see when we come and we work with a client is that they're not quite sure what's going on. They don't want to tell the lawyers until they've figured out what's going on. So a fair amount of investigation has occurred, and it is not under attorney-client privilege because it hasn't been done at the direction of counsel, and it hasn't been. We're anticipating potential litigation, so the lawyers want to be involved, and that protects the company. And a lot of times these investigations go well down the road before the lawyers get involved.
Yeah, it's really been a business model, and obviously we do it, and it's not a really big plug because I'm not supposed to be plugging, but a lot of firms.
But you will.
I will. I'm shameless. No, but you hire the law firm then hires the consultant. And then they go in and do an A to Z risk assessment analysis, and everything that happens then is protected. The older model, even 6 months ago, older model, were silos. So you hired your consultant, you hired your law firm, and to Lisa's point, everything the consultant did it's not under the attorney-client privilege. And that becomes dangerous down the road when they start to unravel what happened, and how it happened, and why it happened.
Although it might not be 6 months ago, depending on the company you talk to. Exactly. They may be doing it yet today.
Yes, yeah, most are probably doing it still today.
Yeah.
So we've talked about what to do after a breach. How does a company inoculate itself against this kind of thing well ahead of time, before a breach has occurred?
Well, you do what we were just talking about. You figure out, you don't hire your lawyer. You hire the law firm that actually does this kind of work, hopefully with the regulator, the former regulator of some sort. You go in there, you have a conversation and say, here's what we're doing, here's our problem, we need somebody to look at it, we need to figure out where we're weak, where we're not weak, and the very fact of having done that will ultimately put you down lower on the list when you are breached. And then you have an incident plan, you do the training. That is, I mean, I can't emphasize that enough. I mean, there's a recent case where a CEO was, they targeted the CEO and it was a who's who, and click here to see if you're updated because you want to be on the who's who. The click there just opened the whole company up.
Oh my goodness.
Yeah, and so you need to train everybody from the top to the bottom in terms of what not to do.
So we've been hearing that mantra for 10, 12 years. Train your staff, train your staff, train your staff.
I think even before training, though, I mean, training is critical.
Things, yeah.
But I am shocked by how many companies are not aware of what they have. So we're talking about laws that say we have a duty to notify if certain types of information has been compromised. So if it's social security numbers or names and credit card numbers, so certain types of information trigger the laws that make us raise our hand and say we had an incident. And it is, I suppose it's not surprising, but there are companies that are enormous, they're old, they have legacy systems, they don't know what information they have and where they have it. They know they've had turnover, they've had people retire. So I think one of the first things to do is sit down and get a handle on what's coming in the door, where is it going, and who's touching it, who's interacting with it, because that will...
Informational audit, as it
Yeah,
were.
Yeah.
Well, there's 2 points to that. So one of the things that happens too is companies acquire other companies, and now they've just acquired their data problems, and that often is the issue. And the second is that really the third-party vendors. You're seeing the Wyndham case just came out, and that was a sort of a reminder that you need to make sure that you understand the systems that the third parties that you're using, that you're contracting out to, what are they doing in terms of what are their firewalls, where's their security, and are they
Remind
up
us
to date?
about that case.
Well, it's a hotel chain that was contracting out to other companies, and the other companies, they got breached, and it came in through Wyndham, and then all their information they were taking in through all their hotel chains was compromised.
Yeah.
And it put third-party liability on the first party. And by the way, the regulators are always going to go after the first party. They're going to go after the one that
Always.
companies, everybody in the room, or their consumers, i.e., particularly the state AG, their voters, who they have heard of. So, the target is sort of the new one. So it's target. They're going after target. They're not going after the third-party vendor that target contracted with that nobody's heard of.
And I would say it's fair to say that it wasn't us, it was them argument
never
just
works.
fails every time.
Any other
And it's always the one they want to make.
Any other advice you'd give? Here you have an assembly of people interested in this issue. They want to know what the tools are. What else would you want to tell them?
Well, being interested in understanding that you have to do something about it, and you can't just hide and think, this isn't going to happen to us, is certainly not the way to go. I think you need to have an incident response plan ready to go, even as much as like a notebook. So, because everything just got crashed, who do you call? Who are the comms people? To make sure the lawyers call their lawyers to make sure that you get everything under control. In the post-breach world, in the pre-breach world, you want to sit down and do a gap analysis and figure out where your holes are.
And I would say there's a lot of folks out there that are giving away incident response plans, saying, here's the document. I have had clients that have clearly copied them from somewhere else, so clearly that you can see that the other company's name remains throughout the document.
Not a good idea?
It's not a good idea because we don't know if it's going to work for our company. And this is supposed to be our playbook that tells us how are we going to react. So we want something that's going to work for us, and we have to test it. We have to try it. And forgetting about the personalities, I think, is one of the most dangerous things. Lawyers are so fixated on what the law is that we forget about the decision makers are making the decisions for many emotional gut reaction reasons. Those are going to have legal implications for us. If they decide, I don't care what the law says, I'm going to tell everybody everything right away. That has a legal implication on the organization. So really getting a clear handle on who are the players in the room and how are they going to react in this stressful moment so that we can manage against that. And maybe we need to take some time to calm them down before a real incident
If
happens.
you can predict that, that's a very tough thing
Well,
to
but
get a
as
handle
Liisa
on.
just said, I mean, she glossed over, but I think it's very important. I want to just highlight is the testing. I mean, you need to do the internal testing. You need to bring in a Jayson and find out, either do it internally or from the externally to figure out how easy it is to hack and where the doors and windows into the system are.
Yeah.
Great. Liisa and Doug, thank you both so much for your input here today. It's been great. Again, I'm sure you all have questions. Again, let me urge you to use your email and send your questions to legalreform@uschamber.com. Liisa and Doug and Jayson will all be sticking around to field your questions in a little bit. Thank you both very much.
Thank you.